We are back on Morning Line. Thanks for joining us on this Tuesday. I'm Nick Barris. Our guest this morning, elder care attorney, elder law attorney, Barbara McGinnis. Good morning to you, Barbara. And we had a caller wait through the break. Not sure what Ricky wants to ask, but let's find out. Good morning, Ricky. What's on your mind?
Good morning.
Hi.
When I was wondering, okay, if you ain't got no power of attorney and your wife gets sick or you get sick and you ain't got no kids, what do you do then?
Okay.
That's what I was wondering.
No kids. And you, how about, are you also a power of attorney? You also thinking with regard to a will? Do you have a will in that situation, or what if you don't have a will?
I ain't got nothing.
Okay. All right. You know what? The thing about Ricky is he ain't got nothing. He is not alone. I mean, there's a lot of people. Right. It's amazing how many people maybe who don't have wills or don't have power of attorney. So first, lay this out. If you don't have any of that, and God forbid his wife dies, how is that estate handled? Doesn't it automatically all just go to him anyway because they're married?
It would in that instance. Now, how the title of those assets actually are transferred to Ricky, ordinarily, it's very common for us to own our house with our spouse. So first to die, the remainder, the surviving spouse will inherit that property without probate process. But, maybe there's a bank account in just her name. There may or may not be any way to get that transferred to him, even though that's where it would go, without the probate process. And probate is court-supervised estate administration. So the answer is very simple. It sounds like Ricky has capacity, and probably his wife as well. Go get your documents done. You may not need the expertise of this firm, and you could find an attorney close to where you live that could help you put powers of attorney in place and a nice simple will. But like you said, all to each other, you own things jointly, first to die, not going to be a problem. But guess what happens when the second spouse passes away? There's not a spouse to inherit. There are no children to inherit. By operation of law, it would revert back to the parents of the surviving spouse that subsequently passed away. And if the parents aren't alive, then it goes out to siblings. And so sometimes, yes, there is a plan in place by the state. It is called intestate succession planning. The state does not automatically take it. It does trickle down through bloodlines, but it's still maybe assets going in places you didn't want them to go. So putting a will in place helps prevent that from occurring.
And I'm guessing someone like Ricky might say, well, I don't have that many assets anyway. I mean, at what point do you decide you need a will? Should you have one regardless, even if you just have very few assets in a smaller estate?
I think so. Because there's a few things, that you can do by will. Now, let's say Ricky and his wife had children. Well, one reason you'd want a will would be so that you could name the guardian of your children if both parents were suddenly deceased. Car wrecks happen, bad things happen. So it's only by will that you could name the guardian of your children. Even small estates need a plan, and you certainly need powers of attorney in place. You need to think through your asset profile so that you have named beneficiaries on your life insurance, on your retirement accounts. It is not just the best thing to do to sit there and put to my estate without some real thoughtful consideration that is exactly what you want. A lot of times it's not what you want. You want a named beneficiary there. So it's worth planning.
Okay.
I think anybody that, an adult, you own anything, it's worth putting together a plan in place. Obviously, the more complicated your life is, blended families, lots of assets, they can be more complicated estate plans, and you may need highly specialized attorneys to help with that.
Gotcha. You know, I get questions occasionally on this because these ads run an awful lot. I've asked this before, maybe of you, but I thought maybe you could revisit it because I've had a few people text me just asking me the same question. And they see the ad on TV, which you probably have, with Tom Selleck promoting reverse mortgages. And it plays a lot. And Tom's very good. And I think he's clear to the point of talking about what they do. And he says it's not for everyone, which I think most people would agree. But for some, it can help. From your perspective, and I know I've talked to Tim and Chris about this, that you both agree that maybe it's for a small portion of the population where it really could work. There's nothing wrong with them. There's nothing illegal with them. But how would you counsel a client of yours who asked, what about this? Tom Selleck talking about the reverse mortgage. Is this right for me?
Well, an in general statement would be, it's generally a last resort sort of decision, because if you have liquid money may be easier to spend. It may be less expensive to spend your liquid money. But let's assume that you've exhausted your liquid resources and the equity in your home is what you have to either support your, I wouldn't say just support your lifestyle, but maybe support your care needs. And you're wanting to stay at home, and you can't, because you have to be over the age of 62 and you have to be living in your home to use a reverse mortgage. So pulling out that equity can help you achieve your goal of receiving care and staying at home. But it's going to be a debt and that needs to be repaid. Perhaps you don't have children to pass along a house to, and so you don't care if there's equity. You'd rather use that, and you don't really want to just sell your home because it's your home. That's where you want to live.
So for someone like that, it can make sense. I guess case by case as it goes, and I think for some people it's exactly what they need, for others not. But I see what you're saying about a last resort, and as I said, that maybe is a smaller portion of the population out there. I guess you can't forget too that, you know, these reverse mortgage companies are doing this too because they're in a business and they're going to make money on these deals, right?
Right. It's always about follow the money. You know, they're not doing it as a charitable event. There are fees and interest rates, but still it may be easier for certain people to use a reverse mortgage than to take a home equity line of credit, because you may not qualify for a home equity line of credit depending on your the amount of your income. Could you repay that? A reverse mortgage defers repayment until you're moved out of the house or passed away. And whereas a home equity line of credit, you know, interest is accruing and they expect some repayment sooner than later on that. Another estate planning scenario that occurs often that needs special attention is planning for people with special needs. So if you have disabled family members, children, or a spouse, you don't have to disinherit that person. In fact, you can't disinherit your spouse, and perhaps you shouldn't disinherit your special needs child. So there are provisions that can be made in a will or in a trust for those special needs individuals to have a trustee manage those assets, the inheritance for them, where it could be used to supplement the government programs that they are receiving and probably need to receive, whether it's supplemental secure income from SSI or maybe Medicaid. And those are asset limited programs, and you would want to have the special needs trust in place.
Okay, and I've got a couple questions. I want to follow on that with an example. Real quick, though, it may not be on this topic. We have a caller. Let's take Larry real quick, answer that, and we'll continue talking about special needs. But Larry, good morning, Larry. What's on your mind?
I was wondering which is the best, a trust or a will?
Setting up a trust or a will. Okay, I'll let her define the two of them, and we'll see about your options. Okay, go ahead, Barbara.
Well, usually the advantage to using a trust is most trusts are designed to avoid the probate process. So a lot of times if you own real estate, especially if you own real estate in more than one state, you would like the idea of having a revocable trust to hold that title to those real estate parcels for you so that you could pass them along without the need of court supervision, i.e. probate. A will is designed to be probated. That's another misconception that a lot of people come in here with. They think they have a will that it says this is the person that's going to administer my estate and this is who I want to receive my estate, so it doesn't need to go to court. Absolutely false. A will is designed to be probated. Now, sometimes you can have both because maybe you have a trust, you remember to put your real estate, title it to the trust via a deed, but you don't remember to put the rest of your assets, or you don't want to deal with retitling bank accounts or investment accounts. And you have what is known as a pour over will. That's P-O-U-R, pour over will, that is could be probated. And the point would be that it literally takes those assets in your name only, pours them through your estate into your trust so it can be administered under the terms of your trust. A lot of times trusts can have particular provisions that would not be allowed in a will, certain conditions of inheritance perhaps, and you may want to state that in a trust. So one's not better than the other. It just means they're both tools, and you need to know what goals those tools will help you accomplish and what's right for you.
Gotcha. Yeah.
Again, you're paying for the counsel when you seek an attorney's help, not just the document.
Yeah. So that, Larry, the point there would be, and maybe you've got a mind of your own on what you're going to do. If not, that's something where you have your options. You get with, a lawyer who here's what you want to do, and then you'll get the recommendation on what would work best for you. We'll take a break on that note. When we come back, we can take more phone calls, 737-7587 for elder law attorney Barbara McGinnis, and kind of want to follow up a bit on setting aside and estate planning for those special needs. Parents sometimes wondering what's going to happen to my special needs child when I go, and how that works out. So more of that and more of our conversation right after this. Stay with us.